Well, good evening, everybody, and welcome to our broadcast. This is all about the Building Safety Act, which is a hugely significant piece of legislation for our industry and for you as controllers of your buildings. So we thought it was important to update you as to how things are progressing with the legislation and to go through in a bit more detail what the implications are for you. So just before I start that, we will start with some introductions. So my name is Sue Petrie and I'm on the board at Rendall Rittner. My responsibility is risk. So the health and safety, fire safety remediation team and legal teams report into me, and I will be hosting this broadcast today. I'm going to hand over now to our guests. So firstly, Peter Clark, if you could introduce yourself.
Thank you, Sue. Yes, I'm Peter Clark. I'm the Senior Director of Risk and Compliance at ARC. I've been with ARC for 4 years now, 20 years in health and safety management prior to that. ARC have been almost 30 years in the safety industry, specialising in property particularly, and my role at ARC is to support our clients and help steer them through which we are about to find out is some very complex legislation that's about to hit us.
Thank you. And Cass?
Good evening, Sue. I'm Cassandra Zanelli. I'm solicitor and CEO at Property Management Legal Services Limited. And as our name suggests, we specialise in the delivery of legal services to the property management sector. Our client base tends to focus on leaseholder owned and controlled companies, whether they be RMCs under tripartite leases, RTM companies that have acquired the right to manage under the 2002 Act, or indeed leaseholder owned landlords. And I've been helping a lot of my leaseholder owned and controlled companies recently in negotiating the complexities of the Building Safety Act.
Thank you very much. And over to Oz.
Good evening, I'm Osman Rankahi. I'm Rendall Rittner's Head of Legal, and along with Vanessa, we work with Sue in devising R&R's approach to the legal aspects of the Building Safety Act.
Thank you. And finally, Vanessa.
Hi everyone, my name's Vanessa Brandham and I'm their Head of Health and Safety, and as Osman said, my role really is to help advise Rendall and Rittner on the health and safety aspects of the Building Safety Act.
Thank you very much. So this evening we're going to be, well, first of all, we've done the introductions piece already. So we're going to be going through, first of all, I'm going to ask Vanessa to go through with you a little bit of the history of why the Act was deemed necessary and what's brought us to where we are today. We're then going to talk a little bit about the role of accountable person and principal accountable person, just to help to clarify that role, which in very many cases you may not be aware, hopefully you are, that you may well be the principal accountable person. We will then go through the key elements of the Building Safety Act in a little bit more detail, so being the golden thread, the safety case, freehold and leasehold certificates we'll talk briefly about, and then the supporting legislation. We'll go on to talk about the Building Safety Director role, and then go through a little bit about the industry's response to this legislation, before finally going through what Rendall and Rittner's response to the legislation is. So just to start with, I will hand over to Vanessa to go through the history.
So this really starts with the terrible incidents at the Grenfell Tower fire that I know we're all acutely aware of, and following that started some inquiries. There's been many going on, but one of the first was the Hackett report, and what this looked at was the industry and not the fire itself, but where there could be improvements made to prevent the industry getting into a situation where we have another terrible tragedy such as the Grenfell Tower fire. So what this report sort of came out with was very many recommendations, all of which the government has accepted. And it really identified the need for clear accountabilities and responsibilities, looking at process where construction of the building needed to pass through different gateways before it could achieve occupancy. Where more rigorous enforcement was required, and the competency around that, both from the building enforcement teams and the management teams, etc. And also looking at better and clearer information, which is known as really the golden thread. And what this led to was a recommendation for a new framework for high-rise buildings. So this led to the Building Safety Act, and this achieved royal assent in April 2022. And whilst not all of it is enforceable as yet, there are elements that are. And the one thing that I think it's clear to point out, that the Building Safety Act is applicable for buildings over 18 metres or 7 stories. So even if a building is perhaps 17.5 metres, but it has 7 stories, this act will be applicable. So I'm going to pass over to Cassandra, who will give a little bit more detail about those responsibilities and accountabilities known as the principal accountable person.
Thanks, Vanessa. As Vanessa has said, Building Safety Act received royal assent on 28th of April of last year, and there are parts of the Building Safety Act that are in force now, so apply now. There are parts of the Building Safety Act that aren't yet in force, but we expect coming into force in April of this year. And then there are other parts of the Building Safety Act that aren't yet in force, and we don't know yet when those elements of Building Safety Act might come into force. So it's a moving feast so far as Building Safety Act is concerned. And what we're looking at today is in particular Part 4 of the Building Safety Act. And as Vanessa says, Part 4 applies to higher risk buildings, or HRBs for short. And an HRB is a building that's 18 metres or more in height, or 7 stories or more in height. Elements of Building Safety Act apply to lower buildings, but so far as this presentation is concerned, we're talking about HRBs, so those buildings that are 18 metres plus or 7 stories or more. And you'll be familiar with the concept of duty holders, because you're probably very familiar with the Regulatory Reform Fire Safety Order, or Fire Safety Order for short, shorten it down even further to FSO. And under the Fire Safety Order, we have duty holders who are responsible persons. As a leaseholder owned and controlled company, so an RTM, an RMC, or a leaseholder landlord, you're undoubtedly a responsible person under the Fire Safety Order, so have duties under Fire Safety Order. Where you have a higher risk building, so an HRB for short, we have additional duty holders. So we still have the responsible persons under Fire Safety Order, but where we have a higher risk building, we have additional duty holders. And these additional duty holders are accountable persons. I use that in the plural because there could be more than one. And the principal accountable person, you'll see that I've used that in the singular because there can only be one principal accountable person. And this is all set down by Part 4 of the Building Safety Act, and we're anticipating Part 4 to come into force in April of this year. So on 28th of April of this year, we anticipate that these Part 4 duties and these duty holders will then take effect. But even though it's not in force now, it's still important to identify who the accountable person or persons are, and therefore identify who the principal accountable person is. Because the lion's share of the duties that the principal accountable person, or the lion's share of the duties, I should say, under Part 4 of the Building Safety Act will sit with the principal accountable person. And we'll look in a minute at what those duties are and explore those duties in a bit more detail. But the fundamental question that needs to be answered first is, who are the accountable persons? Is there one? Is there more than one? And then who out of those accountable persons is the principal accountable person? Because it's that principal accountable person that has the bulk of the duties under Part 4. And what I've done is set out on the slides the text of Section 72 of the Building Safety Act, which tells us and helps us to identify who the accountable persons are. It tells us who those accountable persons are going to be. And then Section 73 comes a little bit later in the slide, and it's Section 73 that helps us identify out of those accountable persons who the principal accountable person is. And Oz, you and I have had many discussions regarding this over the recent weeks and months, and in some cases it's going to be quite easy to identify accountable persons, isn't it? And for accountable persons, we're looking at who the legal owners are, so who the legal owners of the who holds the legal estate in possession, to use the language that's used in the Act, and who's got responsibilities so far as repair and maintenance is concerned in relation to the common parts. And you can see on the screen now what common parts means in this context. So in some cases, Oz, it's going to be quite easy, isn't it, to identify who the accountable person or persons are?
Yeah, I think so. Primarily, we'll be looking at who owns the common parts at a site, or if it's a different party, who has the obligation to repair those common parts. And I think in a more straightforward building with a more straightforward legal structure, that will be fairly easy. But I think, as we've discussed, Cassandra, there are going to be some situations where that gets a bit more complicated. And actually, I think it's going to be when we need to identify who the principal accountable person is that issues might arise. So taking an example, I think if we've got a straightforward-ish building where there's a freeholder and a separate residence management company, I think it probably comes down to who has the repairing obligation for the common parts. But presumably difficulties will arise where there are different elements of the common parts, which are the responsibility of different people.
Absolutely. So if we could flip back to the slide just before that, that tells us about common parts, because when we're looking at common parts, we're looking at the structure and exterior of the building, aren't we? And then any other part of the building that is provided for the use, benefit, or enjoyment of the residents of more than one residential unit. So the internal common parts, essentially, for want of a better way of describing it. And so in Oz, in your example, it's important to look at who's got the obligations in relation to the structure, and who, if it's somebody different, that's got the obligations in relation to those other parts of the building that are used in common by the residents. And that will help us to identify whether we have one accountable person or whether we have two accountable persons.
So I can think of one example in our portfolio where the exterior of the building, so the actual walls of the structure of the building, is one management company which is controlled by the freeholder, and then everything that is internally, so things like compartmentation, fire doors, everything within the common parts apart from the walls are controlled by a residence management company. So in that instance, who is likely to be the principal accountable person?
Go on, Oz, you look like you're going to answer that
one. I suspect Cass and I are both about to say that we can't be certain without really getting into the detail of it, but on that hypothetical example, it's likely to be the first party because it ties back to the structure and exterior of the building. So if it's neatly divided up so that party A has the structure and the exterior and the responsibility for maintaining it, they are likely to be the principal accountable person.
You're likely to have, I agree with you, Oz, likely to have potentially two accountable persons there, and that's when we then need to look to Section 73, which is next slide, Sue, as to which of those two accountable persons then become the principal accountable person. And this is where, Oz, I don't know whether you share my view in relation to this, the legislation isn't perhaps as helpfully drafted as it could be. That's perhaps why we have the ability, I say we, there is the ability to apply to the First Tier Tribunal Property Chamber, or FTT for short, for the FTT to be able to then make a decision as to, out of those accountable persons, which of those accountable persons is the principal accountable person. So it's really, really important that we identify who the PAPs are, sorry, who the APs are, but absolutely that we know who the PAP, the principal accountable person, is, because they've got the duties, or the bulk of the duties, under Part 4.
That's really useful. So in most cases, it's going to be quite straightforward, but in some cases there is that route through to be able to establish if there's any difference of opinion as to who it is that holds that role.
It becomes more complicated where you have more complex buildings and more complex structures of title. So where you have lots of intermediate leases, and where you have, in your example, Sue, somebody responsible for the exterior and then somebody else responsible for the interior common parts.
But I guess the important thing is that everybody still has, they're all accountable for this. Everybody has a duty, but it's the principal accountable person who would lead on how we deliver the various elements of the Act.
Absolutely, and there's that obligation on the part of accountable persons to cooperate with each other as well.
Thank you very much.
So, following on from that, one of the key elements of the principal accountable person's responsibilities is to hold and maintain a golden thread. And this golden thread is really just a series of information that will help establish decision making during construction, design, planning and management of a building. So a lot of this information may be static, such as the planning consent evidence that was issued, and the fire statement that's required in one of the first gateways of planning within the building. And it will also hold information that will be subject to review, but remain a little bit more static, such as the fire risk assessments and fire management plans. So these are documents that highlight how fire safety within a building is managed, and it is of course subject to review depending on any changes within a building. And as we know, the requirements of the Building Safety Act certainly would constitute a major change for a building, and this information will be required to be held digitally, and so we are working on our systems in association with ARC to help us create that digital golden thread of information. And part of the support for that will be the safety case, which is on the next slide. And this safety case and safety case report is really a justification of why a building is safe to live in, and that will include information that is more of a live document. Not that the golden thread isn't live, but this will be more subject to change. So it will include information on maintenance, how we engage with residents within the building and yourselves who are our clients, as well as looking at the structure. And as that information is then used to help build the safety case report, and that report is really a narrative around why that information we're providing is applicable to a safe building to live in. And again, just to be clear, that this safety case report and golden thread is for buildings that are 18 metres or more, or 7 stories. So these elements are applicable to those high-rise buildings.
Vanessa, what do we know about timescales at this point in time? What will we need to do by when?
So the first timescale really will be the April this year, and that will be for us to register the building with the new Building Safety Regulator, which is the Health and Safety Executive. And so for that, we're going to need to know a little bit about our buildings. We're going to need to know who the principal accountable person is, if there are other accountable persons, who they are, and information we should already know about our buildings, such as the number of stories and how many staircases we have, etc. And then that will build a register of high-rise buildings for the Health and Safety Executive, so that they're aware of what is their scope. So that's will start to open essentially the registration in April, and probably close to when Cass alluded to earlier, around April 28th this year. And this is still information we're still waiting on for the information that's required, but we are working to gather that information, so we've got as much upfront as we can.
So it opens in April, but I think we've then got until the autumn, haven't we, to register buildings. So they haven't all got to be registered in April, which is lucky, because we don't yet know exactly what it is that we've got to gather in terms of that information. So,
and I think it's worth pointing out as well that responsibility to register will sit with the owner of the building. Now they obviously can ask their managing agents to do that, but if it's not done, the government made it really clear in this legislation that it will be the owner that is committing the offence. So it's worth pointing that out as well, that this is an additional thing that managing agents are being asked to do by many of the building owners.
So being the principal accountable person that would have that responsibility then, Peter?
Yes.
Okay, good, thank you.
So what I've alluded to is that there are elements that still we're not clear on, because there's not yet guidance or supporting legislation that's published. So we know that the government are working on additional supporting legislation, and that is starting to come out. We had the Fire Safety Act published, and that did put some obligations on some buildings that are 11 metres plus, but also for those that are 18 metres plus, such as the structure of the building, where that must be considered when looking at fire risks within a building, as well as the fact that flat front doors do form part of the responsibility to manage fire. So the reason that's important is they do create a safe corridor. The Fire Safety England regulations as well, they've more recently been published in January this year, and they look at the requirement to have information for the fire service in the means of a premises information box for buildings that are high rise. And the Land Morton Tenant Act is just an example of other legislation that is non-health and safety related, but has had an effect elsewhere. And hopefully I've been clear to say that there is more to come, and some that we know that is to come is things on mandatory occurrence reporting. We know that there are going to be certain types of incidents that happen within a building that we're going to be required to report to the Building Safety Regulator. And when I say we, I do mean the principal accountable person, but we're all in this together, I'd like to think. And the more information around what will be entailed in the safety case and what is required with the safety case report, which I know that Peter, you know a bit more about.
Yeah, the safety case report, I think, is going to be what compliance hinges on, essentially. So it's a narrative document written to support your golden thread, if you like. So if you imagine your golden thread as a big list of documents that you have and is live, it's up to date, And then at a period in time, on an annual basis, you're going to summarise and snapshot that in a safety case and submit it once a year. But of course, during that year, things might change within the building, and you need to revisit that safety case as well, and adjust and amend your safety case report. So one of the overriding things that we found by talking to the regulator is that they're not expecting on enactment, and when they call in these safety case reports, they're not expecting to see version 1. They're expecting to see a well-developed and fluid document that has lived and breathed the way that building is living and breathing. And it's also important to mention that safety case report is very building specific. So it's not like an organisation can have a generic safety case report for their portfolio. Very, very much building specific now. So we are working with the government on what that looks like at the moment, which is a little scary for some people, as we're talking about this impending legislation, and we're still not sure what this document will look like. But at ARC, we're pretty sure, and we are working closely with DLUC at the moment to help them understand what's required. So it's a very interesting time for us. Yeah,
it's been the challenge all the way along, really, hasn't it? Because when the legislation was being introduced, and for many years we talked about the role of building safety manager, for instance, and the judgment call is if we had acted on what was going to be in the legislation and introduced building safety manager roles, then yeah, we would have been going down very much a blind alley. So it is a judgment call how quickly you respond to the information that's coming out so that you're ready to get this done, but without going too quickly, and then all the rules get changed and you're left a little bit high and dry. So it is a bit of a judgment call, really.
We only need to look at the building safety manager role that was previously required, which then got taken out. So it is a fine line between jumping the gun and not, but we now know there's the building safety director role that previously didn't exist, that I know Cass is going to talk about.
Linked neatly in there, Cass.
Thank you. There have been a heck of a lot of consultations going on from government in relation to various different elements of the Building Safety Act. One of the more recent consultations, I say more recent because there have been some other consultations recently as well, but one of the more recent consultations has been in relation to the Building Safety Director role, because the Building Safety Act makes provision for resident-led organisations who are accountable persons to appoint a Building Safety Director, and the consultation has looked at what that appointment is and how it works and who the appointment is made by. It may be that you're familiar with the consultation. You may have responded and submitted your views in relation to that consultation. And what I've done is set out on the slide, it's an extract from the government's website, which published and gave details as to what that consultation was. And it really, I think, sets out the rationale behind what government was trying to achieve with the Building Safety Director role. And it recognises, as we talked about before, that there are going to be many resident-led, leaseholder-owned and controlled companies that are accountable persons under the Building Safety Act, whether they are RMCs enshrined under the terms of tripartite leases, whether they are right to manage companies who have acquired the right to manage under the 2002 Act, or because they are leaseholder owned and controlled landlords. A variety of different ways in which leaseholder controlled companies are going to be accountable persons under the Building Safety Act. And as government set out in this explanation regarding the consultation, those resident board of directors, some will have the requisite skills and knowledge to meet their new responsibilities as accountable persons. And it's recognised that these resident directors are often leaseholders and often performing their role as director on an unremunerated basis. So some of those lessee owned and controlled companies will have the the knowledge and the skills to be able to meet their duties and discharge their responsibilities as accountable persons, some obviously with support of managing agents. But it's recognised, say, government, that not all of those organisations are going to have that competence to be able to do that. Those that are accountable persons and those that are principal accountable persons, that they're not going to be able to fulfil their duties under the Building Safety Act. And so the Building Safety Act therefore allows a resident-led organisation to appoint an external director, and that's a building safety director, and that appointment is designed to support that resident-led organisation in meeting their duties under Part 4 of the Building Safety Act. Now, we know that resident-led companies are governed by their Memorandum and Articles of Association, or Memonarts for short, and often the Memonarts can restrict who can be directors of the company. And we know as well that we're bound by our occupational leases and what our occupational leases say in terms of where service charge monies are spent. The Building Safety Act recognises this, and it therefore brings in provisions that essentially override what's in the Memonarts. So if you have a set of Memonarts that say you must be a member of the company to be a director, then the Building Safety Act overrides that so far as building safety directors are concerned, and it overrides the provisions in the leases as well. So it's there to enable those resident-led organisations who perhaps don't have that competence to appoint, at their choice, a building safety director to support them in meeting their duties under Part 4 of the Building Safety Act.
Thank you. So just to clarify and confirm, there's no obligation to appoint a building safety director. It is entirely the choice of each board whether they wish to, and obviously in doing that they will consider what their own skills are, what the skills of the managing agent are in drawing this information together, but they then can choose to have this independent expert that is brought onto the board to help them and support them in delivering their obligations as the principal accountable person. Is that right?
Absolutely, Sue. One of the, or a series of questions that was posed in the recent consultation is how that's going to work in terms of process. Is it going to be a decision of the board? Is it a decision of the members? And how is that decision then communicated to residents? And we'll know a little bit more about that detail once we have government's response to that consultation, and that's awaited at the moment.
Thank you. So I know that some of our clients have asked whether we are going to offer this as a role that Rendall Rittner delivers, the role of Building Safety Director. And we feel that it's very important actually where a board has decided that they want to appoint an independent expert. We think it's quite important that they are independent. So we're not planning to offer this role as a service from Rendall and Rittner. We think we'll be well placed to put a lot of the information together on behalf of our clients. But certainly the role of Building Safety Director, we feel it's important that is quite independent. That said, I think, Peter, that there's something that ARC have at least been considering, isn't it? Although we don't know the details of that yet.
It is. So yes, it is. It's very much like if we go back to that building safety manager role that we know was removed. ARC had prepared to support in that area as well, and this isn't a million miles away from that. So the point you make about independence is really crucial. So we have explored this option with our legal team, and we've looked at independence, and we're going to be offering this solution through a sister company. So a fully transparent solution that is independent. And we feel that this is going to be crucial to many organisations. This is an area which, you know, as Cassandra has said, is still under consultation. We were expecting the government response back by now, and we haven't had that. All we've had is an extension. I think that tells you how complex this area is. So we're finalising at the moment. We're finalising our offering. We're ready to go with it. We just need that final consultation document and the secondary legislation to be published before we can publish.
Okay, thank you. So I'll leave it with you now, Peter. You're going to be
Thank
talking
you.
about the industry response more generally.
Thanks very much, Sue, and thank you for that summary, Cassandra. I think we're in no doubt that this is a complex piece of legislation now, and from ARC's perspective, I think we're in a unique position because we're working on both sides of this. We're working very heavily with the regulator and the legislator here. We're working on the other side with building owners, people that will become accountable persons and PAPs. And we're working with managing agents, so we're looking at both sides of this, and we can see really that this is a landmark piece of legislation that's caused a lot of confusion, and there's a large degree of misinformation out there at the moment as well. None of it's malicious; it's just very, very confusing. So it's a new regime, and the government are keen to stress it's a new regime, and we should really be applauding that because of let's look at where this came from. But these new roles, these new responsibilities, these new relationships will take a while to bed in. So now we see that owners are now going to be accountable persons. So that accountable person or principal accountable person is going to be required to have visibility of the buildings that they own and the safe management of those buildings. Now that's something that hasn't been enshrined in law before, so it is a huge change, and that change has led to a reaction from those accountable people or soon to be accountable people in very many different ways. And I'll look at that in a moment, but they're looking at these new requirements. There's additional requirements above and beyond those traditional PMAs that are currently in place, and over and above what property managers and property management companies have traditionally delivered. It's a big change for them to get used to. Owners, and as they will become known as principal accountable persons, will need support with this. There's new legal obligations to discharge, and they're looking in the main, in our finding, really, to extend the scope of what their property management companies are doing for them, and to look in detail at those agreements that are already in place that may need to be revised. And so if you could move the slide on, I just want to look at the stages of preparedness that we have experienced at ARC throughout the industry. So for context, we're currently working with over 70 managing agents and owners, stroke landlords, to support with this building safety regime. It's an incredibly busy time for us all in property management. It's a very exciting time too. But what we're finding is that the industry broadly is currently split into a few different camps. Now, these will have to be unified at one point. There's going to have to be a uniform acceptance of this new regime. But at the moment, we're looking at some starkly different approaches. So we've got some organisations who are accepting of the new regime. So this is the stage they're at. They understand it's coming in. They understand they have accountability now, and they're already working with their lawyers and their managing agents proactively to agree new PMAs, to agree a pathway through this legislation. And then we are looking at some organisations, and many I've noted here, many are in the build to rent sector, who appear to be ahead of the curve. And I single out that sector because I think it's a fairly new sector to the industry, particularly in terms of the scale that BTR is at the moment in the UK. And so these new companies seem to be more agile, and they seem to understand they can react more swiftly, and they need to understand these relationships that they're generating now on a very proactive level are the future of their businesses, and they're future proofing their businesses. So if we look at the legislation we've talked about so far being relevant to HRBs, 18 metres plus, we're working with some BTR organisations at the moment, more broadly across their portfolios, looking at 11 metres plus. Why? Because they see, very much as we do, that this is the start, not the end point here. And if we look at the legislation as it beds in over the next 2 years, for example, we feel that the 18 metre plus rule could be extended to 11 metres plus. So we could bring into scope an awful lot more buildings. So they're getting prepared for that. And if you look at what's happening in Wales, for example, they don't have too many HRBs. So they're already looking at 11 metres plus to bring into the Building Safety Act. So it's a very interesting time working with organisations like this. And then there's some organisations who are simply unaware of the changes. And we're seeing these organisations leaning more heavily on their managing agents, in more need of support from third parties. And there's an element of not accepting the accountability that has suddenly shifted to them, more out of confusion than any kind of willful negligence, but it's very prevalent at the moment in the industry. And then there are those organisations that are in denial, and we're seeing fewer and fewer of these, I'm pleased to say, but they see this as purely a managing agent issue. The organisations, that are out there that support our industry are very keen to stress this isn't a managing agent issue, but managing agents are here to support. But they're tending to be unaccepting really of their accountability, and looking for ways to contract it out, and even bizarrely how to be insured against this, how to be insured against the criminal acts that could potentially follow with this legislation. So very, very interesting time. So if you don't mind moving on, please, Sue, I want to just talk through how ARC and Rendall Rittner are working together in this new regime. So as I've mentioned before, we're working with government bodies, we're working on consultations, and we're working closely with industry bodies too, IRPM, UKAA. We've just had another consultation with Homes England, and as I alluded to earlier on, we're working with DLUC at the moment on safety case reports. It's a very interesting time for us because as safety specialists for the property industry, this is all very new to us too. So, but our skill sets exist and our skill sets have been there for a while. So we're putting those to good use. We're sharing our findings with the government. We're getting great response and we're getting great feedback from the government as well. So we know the path that we're on and we're happy with that. We've developed a suite of products and a software platform solution. As Sue alluded to earlier on, we've had CUDA in place now across the property sector for the last 14 years. It's just undergoing its biggest revamp since it was launched. It's going to look a lot different and it's going to do a lot of different things because it needs to now. And the idea really is that owners now and these principal accountable persons can start to feel a bit of comfort and assurance that they're in compliance with the legislation. Our goal with working with R&R is to make that assurance, make that building safety assurance as simple and as cost effective as possible. So there's the big question of money, and the cost of this. It's obviously going to cost money, but we're very keen. We've seen an industry really damaged over the last few years in terms of trust. I think we've all been very surprised by the outcome of these inquiries, or some of us have been anyway. But now we're in a position where we've got to accept those findings and give the principal accountable people the visibility that the law is now requiring that they have, and make it as easy for them as possible, make it as simple and as cost effective, so it doesn't impact on the residents as much as it otherwise would. So we feel that in ARC, R&R have a partner that's aligned with their own core values, and we're very happy to support Rendall and Rittner, as we have done now for the past few years. We are a business that is keen to help implement and importantly manage the change that's about to happen. And we see this very much as the relationship that we have transcends that traditional client-supplier relationship. And interestingly, that's a direct response to the challenges of this legislation that's coming in. And so if I can hand back to you now, just to look at the way that Rendall and Rittner are responding to these changes.
Thank you, Peter. Yes. So to summarise, this is complicated. We recognise that there's a lot of implications and new things that we have to get our heads around as an industry relating to the Building Safety Act. And one of those challenges, and hopefully it's come out of this presentation, is it's still not clear. There are still consultations around some of the regulations that we know are still to come on this. So a lot of our focus is on understanding all of that. You can imagine for our colleagues who are at the coalface, yeah, there's a lot of complexity around this as well. So much of our focus has been and continues to be staff training. We have sort of regular training events with them. We've introduced a concept which we call bite-sized BSA, which is literally a series of single sheets of paper which cover the various elements of the requirements of the Building Safety Act, which, you know, the feedback from our colleagues has been that those have been invaluable for them in helping to inform what they need to do now and what they will need to do in the future to respond to the various elements of the Building Safety Act. Over and above that, we're working quite hard in the background, work together with some of the other larger managing agents within our industry and our professional associations, ARMA and IRPM, who together form the TPI now, the property industry. I know Cass is also involved in those public affairs groups, and we're very busy in the background lobbying and engaging with government and various different parties are involved in this to try and make sure that the outputs are sensible and proportionate and workable. We said that we would touch very briefly on the landlord and freeholders and leaseholders deeds of certificate, which is an element which has been included in the Building Safety Act. That's a particularly complicated area, and I think I've had comments from some of the most significant barristers within our field saying that it's the worst drafted legislation they've ever come across. So that's something we're working on in the background, where if we've got buildings that have got particular defects, the freeholder and landlord certificates are intended to establish who it is that needs to pay for that work. But that's probably enough for today, because we're kind of mindful that for most of you that's not going to be something that you need to have to deal with right now. So maybe that's something we'll deal with on another broadcast, but that's just another element that we are dealing with in the background on your behalf. We're also engaging with the Health and Safety Exec as well, the HSE, who are going to be the new regulator for all of this work. And again, trying to feed back to them. They've had a number of consultations and surveys that we've met with them and gone through to support what they're doing to roll all of this out for you. We're consulting with our clients where there are doubts as to who the principal accountable person might be. We're working with them to try and identify and nail that. So if any of you have any concerns over your buildings and you want to discuss that with us, we'd be happy to engage with you and to help to work that out if there's any uncertainty. Fortunately for most of you, that's not going to be an issue. And then also tracking and monitoring all of the regulations as they are delivered, just to make sure that we're on the case and that there's no horrible surprises that we haven't anticipated. So yeah, we're very closely monitoring that as things develop. Peter alluded to CUDA, which is the software that we currently already use to make sure that all of our assets on site, so things like lifts, fall arrest systems, all the other sort of like complex assets that need to be maintained and tested. We already track that through CUDA, and we're working with ARC, who are delivering a new element of that software, which will be specifically to track and monitor those parts of the Building Safety Act, the golden thread, to make sure that our safety cases sort of hang together and we've got the necessary information to go into those. And we're also in the process of doing a gap analysis of our high-rise buildings to assess where there is missing information that we will need to bridge the gap on. And again, I think Vanessa alluded to the fact that certainly for some of our older buildings, where it was never envisaged that we would have to have all of this information, that's disappeared over the years. It might be during sort of transfers from one managing agent to another. In some instances, all of this information wasn't even handed over from developers in the first place. So we're just in the process of identifying any sort of significant gaps, and we'll be working with our principal accountable persons to decide how we bridge any gaps where needed. So there's a lot of work going on in the background, and in the meantime, we'll try and keep you fully informed as well of any other developments. So I think that's it as far as the presentation is concerned. So what we will do now is take a look at any questions that have been raised as we've been talking. And just a reminder to you, if you do have any questions that you haven't posted yet, if you click on the chat button, you should be able to raise any questions that you have. It'd be great if you wouldn't mind giving your names as well, or the buildings that it relates to, but obviously don't feel obliged to do that. We will answer as many of the questions as we can within the time that's remaining to us. Thank you very much. We'll transition into the questions now. So I think I may need to actually put my glasses on for this because it's quite small text on my screen, so bear with me a moment. Right, so the first question comes from Jonathan. Thank you, Jonathan. And it is, does the principal accountable person need to have any qualifications or insurance cover? So I'm going to ask Peter to take a look at that first question, if that's okay, Peter.
Sure, of course so. Okay, let me deal with the second bit first, insurance cover, because that's a slightly easier one to deal with. We're talking about criminal law here, so of course there is no insurance against this. I think what Jonathan, maybe what you're referring to is something like, when we're directors of a business, for example, we have D&O insurance and that can protect us. This is a very different scenario, so there's no insurance policy you can take out for breach of the Building Safety Act, if you like. It's criminal law. And in terms of qualifications, there's nothing there at the moment. There's nothing out there that's well, there's a few training courses for sure. There's a few people kind of pushing these around, and industry bodies are doing training courses but mainly for property managers. So if you look at organisations like Armour, as TPI, they are doing these sorts of training courses, but there's no requirement for a particular qualification. Cassandra, I don't know if you've come across anybody else asking the insurance question, because I've had that a few times now, and I wondered what your take might be on that.
I agree with you in relation to that. Yeah, I've had a few people ask a similar question, but it's, as you say, it's criminal liability, isn't it? And can't insure against criminal liability. I wonder whether Jonathan is getting at the directors and officers insurance point.
Yeah, that's a potential, because it sounds like that to me. So the simple answer is there's no, like you can't be insured against getting a speeding fine, for example. So yeah, that hopefully answers that question, Sue.
Thank you. I guess the only thing I would add as well, though, and I'm kind of mindful this question came in quite early on in the process, so it may well be that the conversations that we've had already around the role of the Building Safety Director, for instance, would help to alleviate some of the concerns over that, because it's the role of the principal accountable person is to see that this is getting done, really, isn't it? Rather than necessarily having all those expertise themselves. So whether or not it's that they instruct Rendall and Rittner to get these things done on their behalf, or whether they opt to go with a building safety director or a mixture of both for RMCs, then the key thing I think that would be considered is whether they've acted reasonably in getting these things completed. Is that fair to say, do you think?
Yeah, I would agree with that. Yeah. The law, there's clauses in the law which talks about that neglect, consent, and connivance. So obviously in areas where an individual consents to wrongdoing or connives or is willfully neglectful, there will be prosecutions, and quite understandably, it's the same criminal law process that we are used to in the UK.
Thank you. Okay, so going on to a question from Mark here. Will the responsibilities under this Act impose any additional duties on R&R as a property managing agent? I'm going to land that one on Vanessa. Vanessa, if you don't mind. our first person to make the mute mistake.
Yes, sorry. So additional duties on R&R. It directly doesn't. However, as we will be assisting, we will certainly need to provide assistance and competent assistance at that. Where there are perhaps more obvious duties on us is where we act as the responsible person, which is under the fire safety legislation as opposed to the Building Safety Act itself, and that is where we act as the responsible person and we will manage fire. So there will be more details and responsibilities that will be clear that we will need to assist with, but in terms of the Building Safety Act itself, the others may want to comment any further, but the clear responsibilities and the lines sit with the principal accountable person and the other accountable persons. So directly, the short answer is no.
Anybody want to add anything to that at all?
I tend to agree. I think Mark's question there, if we look at that in detail, we've got the word responsibilities, you know, so and I think this is one of those common things that is getting a little bit mixed up, as Vanessa says, you know, responsibility, the responsible person, that comes out of a different piece of legislation. So if we're talking about this act as we are, responsibilities fall with the accountable person or the principal accountable person, and duties as well is another key word in that question. They sit with that accountable person or that principal accountable person. So in terms of activities, I would say, yes, there's probably some additional activities that Rendall and Rittner will be doing, but ultimately, if an offence is committed, the offence will be committed by the accountable person.
Okay, thanks. So yeah, and just to clarify a little bit further, I mean, obviously, I think our role as managing agent is kind of like, you know, friendly advisor, and yeah, we would look to certainly work with our clients and the principal accountable person to make sure that yeah, they're supported in complying with this work. So in practical terms, I know a lot of the work that we're doing in the background is looking at the bits that we can do to help and support with this, if instructed to do that. Those bits where we think we would need additional expertise to come in, and where it sits outside of our skill set. So, you know, it may well be some elements that we need to procure on behalf of our clients. And then some other clients may choose to, you know, have this done almost entirely separate from us through a building safety director role. So it is an ongoing conversation, I think, but certainly in each case we will be sort of looking to discuss with each principal accountable person how they wish for us to support them in delivering this work. Hopefully, Mark, that answers your question. If not, we can come back with an ancillary question. So the next one is from Gayleen, and it is saying, is an RTM company as a whole the principal accountable person or a single director of the RTM company? So I'm hoping that we've probably answered that, that yes, it can be a corporate body that is responsible, but equally each director would have responsibility for seeing as individuals. So I think it kind of falls in line with general health and safety law in that yeah, each person can be held to account in terms of their role. But equally, that role of building safety director, where there are concerns, if we've got particularly complex buildings, then that is where that role can kind of mitigate those obligations or risks from a single director. Anybody want to add anything on that? I'm not sure I made that particularly clear answer. I'm going to go back to Cass.
Yeah, as you say, Sue, it is the body corporate that is the principal accountable person, rather than picking on a single individual director to be the principal accountable person, if that's what the question was driving at. But as you say, as with pretty much all other offences that are committed by companies, if an offence is committed under the Building Safety Act, then it's committed by the company as a corporate entity and every officer in default. But it's the the corporate entity that's the pub.
Thank you. Okay, I think another one from Peter. How and who confirms the height of the building?
This is interesting because I was asked this today whilst I was on site at a building which was being argued that it wasn't 18 meters, it was 17 meters and something. But I stood back with the person who will soon be the principal accountable person and counted the stories, and there were 7 above ground. So above ground, we're not looking at subterranean levels. Above ground, number of stories 7, and it's in scope. In terms of height, there is an approved methodology, so it's approved document B. You'll be looking for a diagram D6, which tells you how to measure a building. When I say you, will be looking, whoever you're engaging will be looking at that document to calculate. And again, it goes from ground level, we can ignore subterranean levels, basements, etc., to the floor of the uppermost occupiable floor. So the floor level of the uppermost occupiable floor gives you the height of that building. The who confirms bit is an interesting one. So the principal accountable person will need to know this because you've got to register your buildings, but again, it's unlikely that you will be doing that measuring. So that will be a surveyor, or in ARC's case, if we're doing a fire risk assessment of the external wall, which again is a requirement if there isn't one already in place, our engineers, our fire engineers calculate the height of a building. So it would be a specialist to calculate that, particularly if it's borderline.
Yeah, thank you. I mean, in most cases it's not, is it? It's quite clear, you know, that it's much higher or much lower. Although we have been known to count bricks and also count the height and number of staircases.
Absolutely,
stairs is the other sort of like rough way of doing it. And then if it is borderline, you have to have that particular measure, which is an expert role.
Yeah.
Thank you. A question from Karen. I understand then that aspects of the health and safety regulations don't apply to buildings only 4 stories high. Yes, that is quite correct. We sent out a note before, and if anybody hasn't seen that kind of does give a table within that note as to what obligations there are within the Building Safety Act for buildings which are below 11 metres. And then buildings 11 metres to 18 metres, and then buildings that are above 18 metres or above. So that there is a summary there, but please feel free to reach out to us if anybody hasn't seen that and wants to have a copy of that. I'd be happy to reissue that to anybody. Next question is: the majority of property owners holding the legal estate are corporates, so the responsible person can be a corporate entity. Have I gone back one? That might be a repeat of a. No, that's it. Yes, so I think we have covered that one now, haven't we? Already, yes. The next question: I was of the impression from my property manager that the principal accountable person was to be R&R. I'm not sure that this is true based on what has been said. Yes, Peter, that is quite correct. So under the terms of the legislation, as outlined within this presentation, the principal accountable person is quite distinct from Rendall Rittner, although obviously we would look to try and support you in making sure that between us we deliver those obligations that you have as the principal accountable person. Next question: would you work with the Institute of Directors to provide suitable courses for directors of resident companies? That's a really good question. I think the short answer is yes. And also, as I referred to at the back end of the presentation, we work quite closely with the TPI as well, who are a professional association. And I believe that they already run some courses relating to resident directors, which we'll be happy to point you in the right direction for that. But equally, yes, if the Institute of Directors is looking to run courses, we'd be very happy to get involved in that. If you wanted to message me directly outside of this, or put your contact details in the sort of like private Q&A area, we'd be happy to pick that up. The next question is from Mark. Would R&R not discharge the obligations of a building safety director conducting the relevant studies and cases as part of the general management duties. Currently R&R deals with fire safety and other issues. I'm going to pass that back to Vanessa to answer.
Sorry, so could you repeat that? I just dropped out.
Yeah. Oh, sorry, apologies. Yes, the question was, would R&R not discharge the obligations of a building safety director, conducting the relevant studies and cases as part of the general management duties? Currently R&R deals with fire safety and other issues.
Yeah, absolutely we would. And we are preparing for that at the moment, and the building safety director role would sit outside that should they wish, and they would carry out some of those duties, but equally we are happy and sort of willing to work with some of our partners such as ARC to help deliver on those duties. So yes.
Yeah, so I think to clarify, the obligations under the Building Safety Act are significantly more than we've previously had to do. So it doesn't fit within our normal day-to-day duties as managing agents, but equally, we're sort of mindful that, we do have, in most cases, when we've been analysing this, we do have the expertise and we're happy to support in that. It's really for our clients to decide how they want to discharge these obligations. And in some instances, some of our corporate investor landlords are choosing to carry out this work for themselves, but obviously supported by us in providing information. In other instances, resident directors are already indicating that they want to sort of rely quite heavily on us to do it. And in other instances, we know that our resident clients are looking at the role of an independent building safety director. So there's lots of different ways to address this, and yes, we're very, very happy to support and are putting plans in place to do that. So if you discuss with your property manager initially what you think would work well for your building, but we're all there in the background supporting and putting plans in place to make sure that you have the necessary expertise at your fingertips to deliver this. Next question, who decides if the resident is competent for the role of building safety director? So I'll just clarify that one. I think it is envisaged that the role of building safety director will be a professional role. So it would be fulfilled by somebody that has that specific expertise to offer that service, rather than being a resident director. Although equally in a lot of instances, we know a number of our resident directors who may well be qualified and feel they're qualified to fulfil that role. I'm just wondering if anybody would like to add any more to that from the panel.
I think it's a really interesting question because it's kind of layered, and I think the competency of the building safety director does come up a bit. We do know that we've got from TPR there are courses etc. for building safety directors, as you mentioned earlier, Sue, and there's also a PAS, a publicly available specification for that competency level. So that's a way of judging. But I guess that whoever is appointing this building safety director is the person who is deciding whether that person is responsible. And as you say, this is a role the government as the next question alludes to there has already published a figure, a salary figure that they're expecting these people to be paid. So it's very clear what they do and how much they get paid. I think it's less clear, really, if I'm honest, who decides if they're competent. So I don't know if there's anyone else on the panel that could go a bit deeper on that. Maybe not. It's got us all.
Yeah, and I think it's difficult because, as I say, so we bring in the next question on this because I think it is also relevant. So from Bears, according to the government's analysis, it's 66,000 for a building safety director. Not only that, but when an RTM has a pay director, it massively increases the auditing requirements. So this is a huge cost. This is before the extra work needed to actually do all the work and checks and maintenance. So yeah, I think all of that is really valid, and I think added to that, some of the discussions that we've had, with some of the cladding action groups, for instance, and some other parties, is I know there's been concerns expressed as to whether the government will have inadvertently almost forced the need for a building safety director by introducing or alluding to that within the legislation. And I think as Cass made it quite clear in her presentation on this, I don't think that was what was intended. But I think it remains to be seen what the consequences of that are going to be and how this is going to play out. And again, I think, as Cass said, this is an area that they are still consulting on. So it is very live, and we've not seen the outcomes of that consultation. I know the deadline for feedback on that has now passed, but we've not seen the outcomes of that yet, Cass, have we?
No, we haven't. We're still waiting that. There are a couple of points perhaps to flag in relation to the second of those questions that you've read out, Sue. The figure that's been given of 66,000, I wouldn't want people watching this broadcast to start worrying that if they employ a building safety director for their building, it's going to cost £66,000. My reading of the government's analysis is that the expectation would be that a building safety director would be a director of more than one building. So that 66k isn't 66k per building, it's 66k spread across a number of buildings. So please don't have too many sleepless nights regarding that. The second part of the question talks about the costs of employing a building safety director, and it's quite right that there is going to be a cost associated with that. If you go down the building safety director route, you're employing a professional, and they are going to want to be remunerated for acting in that role. The question talks about auditing requirements and increasing the costs based on that. What the Building Safety Act does is that it implies certain terms into leases. And I think this may be a question that comes later, so that the accountable person and the principal accountable person are then able to recover the costs via the service charge mechanism in discharging their duties under Part 4. So it doesn't matter whether you have a good, bad or indifferent lease, Building Safety Act steps in, and when Part 4 comes into force and implies those terms into your leases so that you can recover the costs via the service charge. And one of the things that you are implied, or one of the things that's implied into leases, is the ability to recover the costs of the building safety director if you choose to appoint a building safety director. So those costs come via the service charge mechanism. They're not a cost, and that's a corporate cost, because often we make a distinction between costs that are recovered by the service charge mechanism and then company costs.
All of that said, I think it is still a very valid point, because and it remains to be seen. I don't. We and TPI are lobbying in the background to sort of try and make sure that this is as sensibly delivered as possible, and that it doesn't become a sledgehammer to crack a nut. But equally, we're all going to be obliged to comply with this legislation. So we hope that BSE are going to be sensible in the way that this is done, and we are watching closely all the various consultations that are coming out and responding accordingly, and working closely with the TPI to make sure that those responses reflect that desire to make it what it was intended to be, that it makes people safer in their homes without just becoming this huge bureaucratic monster, which I think we're all a little bit afraid that it might become. But we will try and be as sensible as possible in our approach, and to encourage everybody else to be as well. The next question then from Peter, what will happen when all the Manco directors resign, as they can't risk taking on the PAP responsibilities? With many leases, the freeholder avoids responsibility. Well, I think that one has to be for Oz and Cass as our legal bods in terms of the actual practicalities of that.
Well, I think part of the answer, certainly in the view of government, is that that is what the role of the professional building safety director is designed to avoid. So you can pull in appropriate expertise in order to avoid that situation of having lay directors who feel that they are unable to deal with it. What remains to be seen, though, is what is actually going to happen in reality. Cass, I don't know whether you've had much direct experience yet on the sort of on the ground, so to speak.
In terms of whether anybody has actually gone ahead and found a building safety director and appointed, or proposing to appoint a building safety director.
Partly that, but also whether you've seen any potential resignations from RMC boards.
I haven't. Have you, Oz or Sue, Vanessa? No.
Not so far. I think it's still quite early days though, isn't it? Because I think everybody's waiting to see what the practicalities of this are and how it's actually going to work in practice. It's certainly a concern because it does increase those obligations. You know, whether or not if you on the one hand appoint a building safety director, and that there will be a cost involved, although, you know, considering, you know, Cass's point that there wouldn't be potentially a director on just one building, but in the absence of that, I can see why, you know, it would make the role of resident director more onerous than it would have been previously. So I think we just need to wait and see what the actual regulations are and what the implications from that are.
I would probably just comment, though, in perhaps direct answer to Peter's question. If you did get a situation where all of the directors of a company resigned, the company will be defunct and will be liable to be struck off, which is usually something that a company will seek to avoid happening. Obviously, that's going to get far beyond the scope of what this presentation is covering. But I suppose that would be one consequence if it were to come to the point where everyone resigned.
So in practical terms, I think then what would happen is that the rights and obligations around management would revert to the freeholder, I think. Cass, is that?
Yeah, there's normally a clause in the lease that entitles the landlord to step in where the management company isn't performing their obligations. So I suspect that the landlord would exercise their step-in rights.
Thank you. So the next question, how much should we expect managing agents to get involved? I think hopefully we've answered that one. And, you know, obviously we'll be engaging, your property manager will be engaging with you to sort of talk through in a bit more detail the things that we are able to do to support you in your role from a practical perspective. So yes, we hope that, you know, as professional managing agents, you know, we will play an active role in this with you in supporting you as much as we were able. And if we don't have the expertise, then, you know, we do have, you know, teams of people in the background that we can recommend to sort of procure particular elements of this where we don't have the in-house expertise for that. Are the costs of compliance recoverable through the service charge? I'm going to go to Cass on that one.
Yes. Back to what we were talking about a few moments ago. It doesn't matter whether you have a good, bad or indifferent lease. The Building Safety Act, when Part 4 comes into force, implies certain terms into your leases. So your leases will be read as if those terms are contained within them. And it implies terms that enable the accountable person and principal accountable person to recover the cost of compliance via the service charge mechanism.
Thank you. And I know that's one of the most recently announced consultations, isn't it? You know, the transparency of how we account for this additional cost within the service charges, which, you know, pending the outcomes of that consultation, I think the point that we're certainly going to be making is that it does need to be very transparent. So I think we envisage it certainly being a separate element within the service charges that you can readily identify which elements of that service charge relate to the Building Safety Act. That's certainly the direction of travel that we're going in, pending the outcomes of that consultation. Next question, is the HSE going to be resourced enough in time to be an effective regulator? Then Vanessa, I think, has answered that and said, this is unclear. They're resourcing for this, however. They are resourcing for this, however, they have put back some deadlines as they're not yet fully resourced. A bit of time will tell about this, but a great question. Yeah, I think one of the things that they've put back already is the point at which we have to provide the safety cases, and that they start to sign off on those safety cases. I think that's been, so far, that's been put back to spring of next year. Whether that goes back further, again, remains to be seen. But yeah, it's a really good question, yeah, and especially in current times. We're very mindful of the fact that money is tight for a lot of people, and so yeah, I think all those sorts of resources are going to be quite stretched. Next question, can you send copies of your presentation slides to attendees? Very useful talks. Oh, thank you very much. And yes, we'd be happy to do that. We'll share a copy of the slides to you after the presentation. Question from Paul Eblin. We've got used to talking in the context of the Building Safety Fund with life critical fire safety risks. The Building Safety Act talks about relevant defects. Do the two terms have exactly the same meaning? Who would like to answer that one? Oh, Vanessa, I think.
I'll answer that. Yeah, in terms of the relevant defects, they are not the same as the risks as we currently know it. A building safety or fire safety incident that may occur under mandatory reporting, for example, that we know is coming out, there's still not a lot of guidance on what the specifics of those are. So time might prove that yes, actually there's an element of crossover, but a building relevant defect is something that has occurred within the last 30 years, and it is a defect from the build, essentially, from a building. So it might be that fire doors were installed incorrectly. I know that Peter and I have worked on a building previously where some fire doors were installed and they cut out the top of the door to put in a self-closer because it wouldn't close otherwise, and so it rendered the door effectively useless, and that would be a relevant defect because it was from the installation at build. So the risks are currently quite separate, but again, we're still waiting for guidance on that.
I know that from the work that we do with TPI as well, I mean they talk very much about mind the gap, and that gap being between those two definitions. I think there's a great deal of concern that that gap may actually result in sort of escalations in insurance cover, for instance, where there's still risks attached to a building where they're not deemed life critical anymore because you can put mitigation in place, but equally that still means that there are consequences for sort of like further risk of destruction within the building. Life risks are mitigated. So again, there's quite a lot of discussion around that and a degree of uncertainty on that.
It's very topical at the moment, isn't it? There was a question that was answered by Lee Rowley. I don't know whether people saw that. Written question was answered earlier this week. I think it was Monday, and it was all about the mind the gap piece, Sue, that you've spoken about between the requirements under Building Safety Act and what's being required under the developer's contract that's out there at the moment, so that the gap that exists between fire safety life critical and the remediation works that might be necessary under Building Safety Act, and it's recognised that there is that gap there.
So next question from Paul Willis. I'm a director of a building. Do I automatically become a principal accountable person? So Oz has answered that and saying no, it's the corporate body which will be the accountable person or principal accountable person. That was the director. You will have responsibilities to ensure the company discharge its obligations. Okay, I think that covers that nicely. Thanks, Oz. Unless anybody would like to add anything to that. The next one, if a resident management company is responsible for the building as a whole, then is it the principal accountable person? Going to go to Oz on that one as well.
It sounds like the RMC would be the principal accountable person. I mean, it's difficult to answer without really getting into the details, and obviously we can't confirm or give advice here and now. But if the RMC is the only party that has any responsibility in relation to the structure and the common parts, then it's likely to be. Though, Cass, I might tag you in as well. Is there apologies, I've got it in my head that there's a slight difference between the two different sections in that when the Act talks about the principal accountable person, it actually gives two options, but without explaining which one takes precedence.
Absolutely, and we've had the some new regulations that have come out recently that are due to come into force. I think it's on the 8th of April as well, that deal with what parts of the building accountable persons are responsible for. I'm not sure that they make things much clearer, frankly, in terms of helping to identify who the principal accountable person is. But when you're looking at identifying your accountable persons, you start up by looking at who owns the legal estate in possession, and then who has the relevant repairing obligations in relation to all of the common parts. And if you have an RMC that has those relevant repairing obligations in relation to all of the common parts, and you can look back at the slides and see what common parts are, then the legal estate owner, or if that's the correct phrase, doesn't then become an accountable person. So if you have an RMC that has all of those relevant repairing obligations, the legal owner isn't then an accountable person. And if you only have one accountable person, then by default, they're the principal accountable person. So it's looking at who owns it, who's got repairing obligations, and whether the company that's got those repairing obligations has all of them. If they have, then the legal owner of the estate is no longer an accountable person. It's not easy.
I think this is going to keep the lawyers in lots of work for years to come, unfortunately, Kath. So, but it's good to have your perspective on it. Certainly, thank you. Really good question next from John Edwards. And funny enough, this is one I know that Vanessa, Oz, and I were talking about only this morning. I'm going to get Cass's perspective on this as well, and it is, what are your views regarding safety work to, or the replacement of, flat doors where under the lease these are demised to the leaseholder? Also, what is the view about whether the costs involved become chargeable or not under the normal service charges? Who'd like to start with that? Go for it, Cass.
Do you want me to start and introduce fire safety order, I suppose, from this? I mentioned during the presentation fire safety order and talked about duty holders under fire safety order and mentioned responsible persons. And I use that in the plural deliberately because in a block of flats, you will probably have a number of responsible persons. So, and fire safety order applies to any building that contains 2 or more sets of domestic premises. So whether you're a HRB or a 2 up 2 down converted house into 2 flats, FSO fire safety order is going to apply. Where you have the flat front doors that are demised to the leaseholders, then those leaseholders, because those flat front doors are such an important part of the means of escape for the building, those leaseholders are also responsible persons under the fire safety order. So they have duties under the fire safety order as well. It's a question that I get asked an awful lot about what happens where you have doors that are non-compliant doors. And as an RMC that's the responsible person for the common parts, responsible person for the building, and then you have a number of options that I suppose are open to you to explore. As I say, the lessee is responsible person for that flat front door where the doors are demised. So you could involve your local fire authority and ask your local fire authority to take some action against that leaseholder because they're arguably in breach of fire safety order. If it's a non-compliant flat front door, you could involve local authority under the Housing Act. You could take action against that leaseholder under the terms of the lease because they are likely to be in breach of a number of clauses in any given occupational lease. So there are a variety of things that you could do in terms of ensuring that you have a compliant flat front door where those doors are demised. Os, do you have any comments or any other pearls of wisdom?
No, I think you've covered that in terms of the different considerations. It's this idea of checking flat front doors and ensuring that they are compliant, and the seemingly conflicting duties of the building owner or the RMC and the leaseholder are relatively new, and we are picking our way through it. I don't think the cost of repairing or doing works to a demised flat front door will fall under the service charge, in answer to that last part of John's question. And so I do think it's going to be a case of going down the routes that you described, Cass.
And the other aspect to that, of course, is if it's identified as being a relevant defect. So if it was part of, they've been defective from day one, then that takes us down a different route as well. So I think we're kind of dealing with these on a case-by-case basis within Rendall and Rittner at the moment, aren't we? Looking at the leases, looking at the implications, and supporting property managers to sort of like go through the route in light of all the different sort of like not quite conflicting legislation, but certainly there's different elements and aspects to consider within this. I'm kind of mindful of time a little bit. We've been going for a while, and I can see numbers are dropping off a little bit. I think if everybody's okay to keep going for a little while longer, then we can do that. Hopefully, I'm just going to ask my colleagues. I know we've been sort of working through some of these and sort of giving answers as we've been going along. So what I'll try and do is pick up the pace. If it's been answered, we'll sort of jump over it to the next one, and then if there's something that's not answered, then we can sort of talk about it as we go through, if that's okay. So next question is, does an external building safety director have to fully participate in all decisions of the RMC, say setting budgets, etc.? I don't think we know yet, do we? Because we've not yet had the sort of consultation on that, or the detailed guidance or regulations on that, unless I'm missing something.
No, although the Act does talk about appointment for a building safety purpose. So I'm anticipating that it is going to be limited to that building safety purpose rather than the wider management of the building.
So I think that they would, as a general principle, they would be advising and supporting the board to make the decisions rather than making the decisions themselves. Cass, is that fair to say? In very simple terms, I know. Why ask a lawyer that?
I suppose it depends whether you go down the route of appointing them as a corporate director or as a director that's an employee. It's there are typical lawyer, lots of different variations. Hopefully the consultation response will give us some clarity.
All right. What is, all right, the next one has been answered. So from Jana, I'm concerned about cost imposed on small RTM companies of 24 or even 80 units. This will impact on leaseholders, which the government have an undertaking would not be happening. Yeah, I think it's a fair concern. I mean, we're very busy in the background. As we're getting more clarity on this, we're sort of like trying to work out the costs that are involved in this. But I think it is a fair concern, and I mean there are clearly going to be cost implications. It just remains to be seen the exact extent of them. I'm not sure we can give you very much comfort on that though, Janet, unless anybody here can think of a way of doing that. From Calm, what would you recommend we as ManCo directors do next? So I think we've alluded to the fact that we are. This is really a starting point. So we've issued a note to all of our clients, which kind of like summarises what's needed for each type of building. There's also specific timescales involved in all of this. So some of the regulations are already in place, and we're making sure that that we're complying with those. So we will be continuing to guide you through this process. Certainly one of the things is to think about, although we don't have sort of precise numbers yet, to start thinking about what the cost implications are going to be. Once we've got better visibility of that, we're going to be sharing information with property managers on that. So certainly engage with your property managers. As I said before, we're there in the background to support them. They're going through a process of becoming more familiar with this. But certainly, we're there to support on that. So I'd kind of start thinking about this, think about the notes that we've sent out so far, raise any questions that you have. And then I think, for each building on a case-by-case basis, we need to put together a plan. One of the things that you might want to think about is whether you want to go through the route of having a building safety director or not. But certainly have those conversations with your property manager and with us, and we'll help wherever we can on it. Anybody want to add anything on that? Another one from Nabil. Thank you for the broadcast. Practically speaking, what is the time frame and availability of appointing a safety director if deemed necessary?
It's an appointment really under Part 4, and Part 4 isn't in force yet, so we've got to wait until that's in force anyway.
So I would imagine, given that the safety cases, well, we're starting to register buildings in the spring, so that will be something that we'll be seeking your instructions on. Yeah, and we're absolutely happy to and geared up to register buildings for you. And we'll be seeking instructions on that. And I think it's probably beyond that we'll start to get that clarity. So perhaps going into summer and autumn is my absolutely unqualified prediction on that. So you've got some time now. We're very much looking to sort of guide you through this process and prepare you for this, and start getting you to think about these things. So I don't think it's quite yet. And as I think Peter said, we're still waiting for the details on that before any company is going to be sort of putting their hat in the ring for that role anyway. So you wouldn't be able to appoint one at the moment. I'm not aware of anybody that's actually offering that service yet, unless anybody else is.
Well, it's interesting, isn't it? Because if you do a quick search online, and you'll see these jobs, some people offering these. But my advice would be just to wait. We've got the consultation that hasn't come back yet. So quite how they're doing it at the moment, I don't know, and I would be wary. So you're absolutely right, Sue. Just we've got a little bit of time with regards to Building Safety Director and the enactment of Part 4. So now is the time just to monitor and wait. And I think Rendall Rittner have a part to play in this in terms of education. And when this becomes necessary, I think we'll bring it back to the table.
Thank you. So the next one, as I understand, the obligation so far as to register the building by between April and October, and to appoint a building safety director. What are the other obligations? So actually, there is no obligation to appoint a building safety director. You can choose to do that, but you're not obliged to do that. So as things stand, it's just registering the building, and then, as I've alluded to before, that table that we summarised in our notes to our clients kind of summarises all the other different things that will need to be done as part of that process. But again, we can kind of go through that and we will recirculate that to this group. Provides a link to the D4 height measuring paper. Yes, I think if we could send out a note after, Jackie, could you make a note of that? I think we can send that that diagram out, can't we, as to how you measure buildings. The next one also is answered. Do you think the additional responsibilities placed on individuals will deter people from stepping up and fulfilling these roles, given it's unlikely to get insurance cover in this? And also answered, it's hard to predict. We can see that some might be dissuaded from stepping up to become directors of RMCs, where that RMC is the accountable person or a principal accountable person. How many R&R managed blocks do you think are involved in this legislation? That's probably commercially sensitive information. So, yeah, it is a good chunk of our, bearing in mind that well, all our blocks is a simple answer, because there are some obligations for every block. There are more obligations for buildings over 11 metres, and then for the complex buildings, that's the majority of the obligations, which given that we tend to specialise in large, complex, high-rise buildings, yeah, it's a good proportion of our portfolio, certainly, which is why, yeah, this is so important for us that we support you in getting it right. Building Safety Director needs to be a professional. Are there professionals that would be deemed automatically competent, say structural engineers? Peter, I think you know you probably looked most closely at this.
Yeah, I don't. Structural engineers, yes, certainly, but no, they won't be deemed competent by virtue of being a structural engineer. That's just one part of it. So I described this role when I first saw the PAS was published. I described this role as incredibly complex and covers an awful lot, you know, from the legal side to the kind of the block management side to the health and safety side to the structural side. So you're going to need to know those things, and it's not it's not that there is one profession at the moment that that would automatically step up and become building safety directors, unfortunately.
But equally, Peter, in the same way as, you know, Rendall Rittner now, very often it's about knowing who to go to procure various elements of this. So one of the obligations is to look at the structural integrity of a building every 5 years, for instance. So it wouldn't necessarily be the building safety director that would do that. It would be the building safety director that would see that get done, isn't it? Correct. So it's making sure that we've got all the different elements of this to build the safety case on. So yeah, I agree. I don't think there's one particular skill set that would cover this currently.
Yeah. You're absolutely right, and it's one of the things that we've looked at as a business, because and again we did it with the Building Safety Bill when it was first published, and we looked at that building safety manager role, and we described these people as unicorns. Like, you're just not going to find them. You know, there's someone that knows all of these things. It's just that ability to be that director and have access. So so we're looking at that, and that so our terms of provision will be really, you know, a nominal building safety director with access to those areas of expertise that they are going to need.
Yeah, so and I think just picking up on Janet's point here, that it would help if we could share the role of BSD, and I think that's what certainly is ARC. Well, I know you can't launch that yet, but I think that's the intention, isn't it? Is that's a role that you fulfil and for multiple blocks, rather than having a single director who is full time on. But I don't think that's what's envisaged by the legislation at all.
No, and again, it's still very unclear, but we will be proposing a fractional model whereby you get a building safety director across a portfolio of buildings or across certain buildings. So I think that's sensible, and I think that approach, Janet's comment there is absolutely right. It would help if you could share, and we don't see any reason at the moment why you couldn't.
Thank you. As there's a request for us to share our bite-sized BSAs, We have already said to our property managers, feel free to share this to clients. It has to be heavily caveated. We can't offer legal advice. And there's a sort of like a form of words that we've given to property managers that they need to sort of emphasise that. But yeah, we're very happy. You know, if there's particular areas that you'd like to have a look at a bite-sized BSA for, if you just ask your property manager, and if they're struggling, they can always come to us to point them in the right direction on those. There's quite a few of them, in fairness, so I don't think we could share them all en masse, but you know, if there's a particular subject area that you'd like to look at, then very happy to share those. Also, you're looking, you're happy with that? Okay, good. The flat front door is demised to the leaseholder, but the lease does not allow the leaseholder to do what they want to the door in order to keep the same look, etc. Then is it still the leaseholder's responsibility? The short answer is yes, but obviously they would still need to get the normal consents that you would need to get when making a change of that. So I think in reality it's about the managing agent and the landlord working together with the leaseholders to make sure that whatever solution is put in place is sort of compliant with the terms of the lease and legislation on that through the consents process. Yeah. And we're nearly there. I think this is possibly the last one. RTM director for Emerald House and Park Rise. It's practically very difficult to fulfil the BSA requirements when we need the freeholder developer to provide information which doesn't exist or is simply not provided. Yeah, and that is a very real challenge, especially for older buildings, because for a lot of older buildings, the necessary information isn't always there, and certainly that's something we're going to be working quite closely with, our experts on, fire risk assessors and particularly ARC, and getting advice where necessary. That if it doesn't exist, is it absolutely necessary? And that's what will be informing the safety case. So we know on a new building it might be more straightforward, but the complexities of this, it's going to be quite challenging. So we need to take it on a case-by-case basis. Does anybody want to add to that at all?
I think I agree with you, Sue. I think there's going to be a point where we just simply haven't got this information. So there's some of it can be recreated. Some of it we can. So there's going to be some piece of information that you just have to have, so a fire strategy for your building, for example. We're not going to be able to build a safety case without a fire strategy. So if there isn't one in existence, or there may be one in existence that is a design strategy, not an as-built strategy. So you're going to have to retrospectively create those, and that's absolutely fine, and that's happening. But those, there's elements there that go back right to you can be asked to go right back to the design and the planning of the building, and some of those might be lost in time, so. But again, it comes down to risk and proportionality, and I think there's been a sensible approach here to what we have got, what we need, and what we can find.
Great. Okay. Well, thank you, everybody. I know that this is complex and quite new. Well, for all of us, it's quite uncharted territory. So please do bear with us. We're working very hard in the background to piece this together, keep track on where we are with the regulations, and keep everybody informed. So it's going to be a little bit iterative in how this goes forward, but hopefully that's given you a good feel for what's going to be needed in the next year or so. Really appreciate your time, and obviously we'll be happy to answer any other questions that you may have at a later date. Thanks very much for joining us.